Thank you for coming this evening. My name is Justin Gilbert. I'm an estate planning attorney with an office here in Folsom. So as an estate planning attorney, that means work with individuals and families to prepare estate plans consisting of living trusts, wills, powers of attorney. Sometimes that includes property agreements, deeds, and so forth. And as part of my practice, we also handle probate or administration of a trust after, kind of guide the loved ones after someone has passed away. So when I'm not busy putting estate plans together, or spending time with these guys. So this is my lovely wife, my three great kids, Peyton there on the right, Jackson in the middle, and then Morgan there on the left. So this presentation is really all about families. And that's really, why does everyone need an estate plan? We want to make things easier for the people we love, whether it be our partner, spouse, our children, or a friend. So the first question you may have in your own mind is, do I personally need an estate plan? And some people would think they don't. They think they have a modest estate. Maybe they're renting a home. So you need to ask yourself a couple questions before you can come to that conclusion about whether an estate plan is appropriate for you. Now, the first question is, well, what happens if I'm out of it and I can no longer call the shots? Are we concerned about what would happen to a child or a grandchild during a period of incapacity? Would that child be put in foster care while the courts sort out the appropriate home for that child? Or who's going to continue to pay the mortgage on the home during a period of incapacity or death to make sure that that home doesn't go into foreclosure and that we don't lose the equity that we built into that home? So a lot of people think they may not need an estate plan because they're married and they have the misconception that, well, I'm married, we took title as a married couple, so everything that I have just goes automatically to my spouse. Now a lot of people have that misconception. And I think that misconception comes from two sources. The one is frequently when a married couple purchases a home, they take title as joint tenants. And so what happens when one spouse passes away? Well, the survivor takes title to that home. Now that's what generally takes place, but that's not always the rule. If one spouse were to transfer a portion of their interest to a third party, well, now we've broken that joint tenancy. Now we have what we call tenants in common. And each person's individual share would go according to their estate plan or the laws of intestacy. Another reason they feel that all their property may go to their spouse is because they've heard that California is a community property state. But a lot of people don't understand what that means. It is a community property state, which means that all the property that we've earned during marriage gets split 50-50 at death or divorce. But that doesn't necessarily mean that our spouse is going to take title to our property at that time. So if you're concerned at all about what's going to happen to your property if something were to happen to you, or what would happen during a period of incapacity, then you probably need to sit down with an estate planning attorney and develop an estate plan to meet your goals. When we sit down with an individual or family to put together an estate plan, we really have two goals in mind: peace of mind and family harmony. A lot of people, they may be going through a procedure, they may have a trip coming up, and they're very worried and concerned because they haven't put their affairs in order, and they're concerned about who's going to step up and be that backup parent for my children, who's going to ensure that they continue in their study of piano or soccer lessons, or do the things for their children that they would if they were there. And then also family harmony. We don't want to do anything that would create disharmony or contention among our children or our loved ones should we pass away. So when we're putting an estate plan together, we always have that in mind. We try to structure it in a way that we're involving the family in the process, and including provisions that would prevent a contest of the will or the trust, and really communicate the process to our loved ones so they understand what our thoughts were going into putting together the estate plan, and so that they understand our reasoning. So there's really 3 keys in putting the estate plan together. Maintaining control during incapacity, so that those, if we have a home, we make sure that the bills are continuing to be paid, the kids are being taken care of, and if we have a business, if we're incapacitated, we need a plan to make sure that that business is a going concern if we're not able to show up for a period of days or weeks. Second key is quick and cheap wealth transfer at death. We don't want a long, prolonged administration of our estate. Typically that involves attorney's fees, court costs, and so we want to have a plan in place that makes it quick, where we know who's going to step up, who's going to administer our estate, administer our trust, work with our family members to make sure that our property goes to our intended beneficiaries. And then we also want to make sure that we protect beneficiaries from others and from themselves. And we're talking about protecting beneficiaries from themselves. Sometimes we could have a child who's what we call a spendthrift beneficiary, just simply meaning someone who's not really good at budgeting their finances, and someone who incurs a lot of debts. They might have creditors problems, they may have judgments, and so we'd want to control the distributions to them to make sure that we've kept that money around for when they really need it. And from others, we may have a beneficiary who has a problematic marriage. There may be a divorce in their future, and we wouldn't want one half of the inheritance going to an ex-spouse.